they do. The gay estate attorney, Richard Bush, is with us now via Skype from Los Angeles now to discuss the case. Richard, how exactly did this fight begin?
The fight began, and this is a misconception, and in fact the jury wasn't allowed to hear this, but the fight began because Pharrell Williams and Robin Thicke actually sued the gay family for having the temerity to question whether Blurred Lines copied Got to Give It Up. So they started this fight. Of course, we finished it, but they started it.
If they hadn't have started the fight, would you have come in?
We believed that it was a copy. We were trying to work things out. I think they got advice that I don't think was very good advice, that if they filed the lawsuit, the gay family would not have the wherewithal or the ability to fight, the financial resources to fight. But they made a bad bet.
Richard, have I got this straight that the jury had to come to its decision on the by reading sheet music, couldn't actually hear the entirety of the songs in question?
Yes and no. So on the one hand, Pharrell Williams and his legal team tried this case in the press by saying they did not copy Got to Give It Up, and it was just a copying of a genre or an era, and it was not a copy of Got to Give It Up. But they fought tooth and nail to prevent the jury from hearing the actual song. And the court made a ruling. It's a rather complicated decision. I'll try and boil it down as well as I can. Because this song, Got to Give It Up, was created before 1978, you could not file the recording as a deposit copy. You had to file written notation. And the court held that our claim was limited to those elements that you could find in the notation that was filed at the Copyright Office. So there were certain elements that we could not move forward on, and certain that we could. And what the court held was that to play the full recording would allow the jury to be exposed to what the court found were non-protectable elements. So what we had to do was prepare very focused audio clips of the protected elements and compare those against the same elements in Blurred Lines.
All right, well, Richard, what could this mean for the broader music industry, specifically hip-hop, which relies pretty heavily on splicing music from decades ago?
Well, I don't think it has any real effect because they have to get a license. If they're copying, they have to get a license. They always have had to get a license. And this is just the copying of a song that they should have licensed. They didn't. It's copyright infringement. It's no different than any other copying or any other copyright infringement claim, despite the claim that this is a copying of a genre or the copying of an era. It's not. It's the copying of a song, and they should have got a license, just like everyone else gets a license when they want to sample or use a composition. Richard,
you got a $7.4 million judgment. What would you have charged? What would your clients have charged for a license before the fact?
Well, we put on evidence Nancy Stern, who works for Quincy Jones Music and has her own company. She does this all day long, every day, and has cleared thousands of uses just like this. And she testified that before the song was released, Blurred Lines, a license would have been about a 50% share of Blurred Lines. And that's what the jury found.
Okay, so pretty close.
Yeah, pretty close.
Could this have been avoided? I mean, when Tom Petty and his team came a knocking at Sam Smith's store, Sam basically said sorry and turned over their money immediately, and it didn't really hit the press in that big of a way. I mean, now we know some of Robin Thicke's very dirty laundry.
Yes, they could have gone a different way. They decided to file this lawsuit, like I said. We approached them, and how did they respond? They filed the lawsuit, and I bet they're wishing they hadn't.
Richard, what do you do now?
What do I do now?
Well, I mean, more precisely, what does Marvin Gaye's estate do now?
What we do now is we file a request for an injunction prohibiting the sale and further distribution of Blurred Lines. And the reason why is that the damages are only for past infringement. In order for us to be able to share in the proceeds going forward, we ask the court to enjoin the further sale and distribution.
So, do you anticipate that Robin Thicke and Pharrell, at the very least, not to mention the record company, will, on the basis of this judgment, enter into negotiations to prevent that injunction? Have you heard anything to that effect from their side?
that's what generally happens. Is the person bringing the claim gets an injunction, and the parties speak about and negotiate how proceeds will be divided going forward. That's the whole point of the injunction.